Hi and welcome to the Lawyer Society Legal Podcast. In this episode, we'll be talking about the inheritance rights of Hindu children born out of void or voidable marriages. For this, you need to be aware of two laws. One is the Hindu Marriage Act, the other is the Hindu Succession Act. In the Hindu Marriage Act, you must be aware of sections 11, 12 and 16 in particular. Section 11 deals with void marriages and section 12 deals with voidable marriages. Subsections 1 and 2 of section 16 provide a legitimate status to those children born out of these void or voidable marriages. Subsection 3 of section 16, however, reads that nothing contained in subsection 1 or subsection 2 shall be construed as conferring upon any child of a marriage which is null and void or which is annulled by a decree of nullity under section 12 any rights in or to the property of any person other than the parents in any case where but for the passing of this act such child would have been incapable of possessing or acquiring any such rights by reason of his not being the legitimate child of his parents. Now basically subsection 3 ensures that this person who has been conferred a legitimate status under section 16 does not have any rights in respect of the property of any person other than the parents' property. So the words other than the parents has been given two different interpretations in the past by the Supreme Court. The first view was that the words other than the parents refers to only the self-acquired property of the parents and not the ancestral property. This was said by three specific judgments, all three from division benches. One is Jinia, Kiotin versus Kumar, Sitaram, reported in 2003, 1 SEC 730. The next one is Neelamma versus Sarojamma, reported in 2006, 9 SEC 612. The third one is Bharatha Matha versus R. Vijaya Renganathan, reported in AIR 2010 AC 2685. Now the second view of the Honorable Supreme Court is that the child who has been given a legitimate status under section 16 of the Hindu Marriage Act will have the right to claim even the share of the parents in the ancestral property. But this view also says that such a claim can only be made after the death of the parent. Now when you compare these two views, the major question that arises is whether the child born out of a void or voidable marriage has the right to claim the ancestral property of the parent. Now before moving on, let me also state that the second view was taken in the case of Revanasidappa versus Mallikarjun, reported in 2011, 11 ACC 1. I will leave the citations below in the description box for you to check out. Now in the case of Revanasidappa, it was said that since the earlier views and this particular case also, they were all rendered by division bench of the Honorable Supreme Court. So it was said that the matter has to be referred to a larger bench of the Supreme Court. A larger bench was constituted much later, I would say probably in the year 2022 or 23, and only after that the judgment of a 3 judges bench was rendered in the year 2023. Now as per the 3 judges bench of the Honorable Supreme Court, the second view is the right view. Now let me just summarize the final view of the Honorable Supreme Court. Point 1 is that a child who has been conferred a legitimate status under section 16 is not a co-partner. That is, he will not have a right or a share in the co-partnership property by birth. Point 2 is that he does have a right to claim the share of the parent in the ancestral property. That is, he has the right to claim only his share which falls within the parent's share in the co-partnership property. Point 3 is that such claim in the share of the parent in the co-partnership property can be made only after the death of the parent. Now this is because since this person is not a co-partner himself, he cannot ask for partition. So he has to wait for the parent to pass away so that he can make a claim in such property. And when he does, it will pass on in accordance with the provisions applicable to or for interstate succession under the Hindu Succession Act. Now it must also be kept in mind that even the undivided share of the parents in the co-partnership property might devolve by way of a will if at all they left behind a will. Now in case the property was already partitioned before the parents had passed away, then in such cases it becomes the self-acquired property of the parent. Then after it becomes the self-acquired property, it was up to the parent to either settle it to this particular child or to the other child or to any other person for that matter. But if such self-acquired property, that is the already partitioned property which has become a self-acquired property, hasn't been settled at the time of the parents passing away, then also the property will have to devolve in accordance with the Hindu Succession Act, either by will or in accordance with the provisions applicable for interstate succession. So now you can actually imagine how this works. A child conferred legitimate status by Section 16 of the Hindu Marriage Act can make a claim in the self-acquired property of the parents. That is not a matter of right, but if the parent has not settled the self-acquired property, or they haven't left behind any will and they have passed away, then the provisions applicable for interstate succession will be applicable, and this particular child can make a claim there. In respect of the ancestral property, he is not a co-partner, so he cannot make a claim before the death of the parent. And if the property has already been partitioned, then too it becomes the self-acquired property of the parent, and as discussed before, he can only make a claim if the parent hasn't already settled it to somebody else or hasn't left behind a will, and even in such a case the Hindu Succession Act will be applicable. And in case the property hasn't been partitioned already, then it will devolve in accordance with the provisions applicable for interstate succession. That is in the absence of a will, and if at all the parents leave behind a will, then the succession would happen in the form of testamentary succession. I hope you found this episode useful. Please do share it with your legal community. Do comment your thoughts. Thank you.